Hey, so I was getting this stuff ready, and Bruce said that he really thought that everyone should hear what we were talking about. So why don't you tell them about all your good angles in your thirst trap
Ladies and
stuff?
gentlemen, we're coming to you live from the
Don't be
internet.
shy now.
Well, so what I've learned from, the back in the day watching The Bachelor with the millennials is that if you want to take a selfie, the problem here in my mobile setup is the camera's kind of pointing up at me. And what you really want to do is you want to take your selfies from a high angle, looking down at yourself for your thirst traps.
Well, Bruce, I'm
That's what I
body
learned.
positive, so I want everyone to see all my chins.
I've learned.
So what angle do we use for that?
Well, you can, maybe you have to do one of those matrix, where you go all the way around.
I'm not that body
360.
positive, bro.
I don't know. Just take 400 photographs going all the way around and then print them all out.
I don't think I ever need 400 photographs of me.
And then individually scan each one with your phone. I mean, that's what.
Like
Can you imagine how long that would take if you tried to take these court filings and scan them with your phone one sheet at a time and turn them into PDFs? It would just take forever.
Honestly, that's a nightmare.
It would take hours. I would probably do it though, but I don't have anything else to do, so.
Yeah.
I don't know. It would just
be. Omar had an operation. What operation?
It would be mind-numbing.
Huh. Let's see.
Didn't he say something about that in your live stream last night? Did he have?
I'm gonna
people's eyeballs were being plucked out or something. Like, what was going on?
Oh no, his wife. Yeah, she had like LASIK or whatever you call it.
Oh, LASIK. Okay, so that's.
No, but I told everyone they
it wasn't Omar. Okay, it wasn't Omar. Then it was. Okay.
No, Omar still has his eyeballs for now. I haven't decided what to do with them yet. They're in my pocket. Good. Or his pocket. Sorry.
I don't want to hear about your balls, Lauren.
Well, Bruce, not everyone needs to know that I had those. that was supposed to stay in the vault.
We're letting it all out of the vault tonight, guys. We're letting it all out.
Why is it that all my male friends think they should air out all my business?
That's how men are. We don't really have. We don't want to keep secrets. We're just men. We just want to watch football, have a beer, drive a car.
Yeah, I don't know. If I ever had balls, I would never stop making
scratch our balls.
Them, so. Okay.
Tell other people.
I think we've reached the ceiling for talking about this at this point in time.
Let's read this legal document.
Yeah, let's. Okay, so I've never obviously seen Omar's legal writing. I've only seen his writing in emails to me, which no one else should ever see.
Yeah.
That is wow. So we're gonna see how this goes. I know there's gonna be like lots of stuff that I don't totally understand, which is gonna suck because he's the person I usually have here to help me with that. So maybe we'll see what Patrick's up to later.
Yeah, we'll muddle through.
Yeah, so we're just doing the shorter one now, guys. It's just the motion to disqualify. I can't go through that 500-page thing right now. That is not gonna happen in the middle of the day. But tonight we'll come back and I'll have a bunch of people with me who can help with that. So
it might
we're just
be
gonna
good.
do a short one now.
I don't know if there's a way to like scan the big document and see if
I think they already did. I saw it somewhere.
No, I mean like visually scroll through it and see if there's anything that's like really new.
Oh yeah.
And then we can just do an initial live where we just go hit the highlights.
Yeah, that'll work. I mean, because we'll do that after this probably, and then it'll make it easier for tonight. But this kind of gives me something to do since I'm too sick to like go out, but I can't go home till tomorrow. So
exactly.
I like to think that this was all my doing. Just saying.
Pretty much.
Yeah. All right. I took out the beginning pages of this. That was just kind of like boring.
Boilerplate.
It didn't matter. Yeah. Let's see. We're not going to deal with that. So he's listing these reasons why I guess David should not be or should be disqualified from the case. First, he goes with conflict of interest. Mr. Gingras has a personal conflict of interest that materially limits his ability to represent petitioner. He's the subject of a pending state bar disciplinary proceeding arising out of his conduct towards respondent in this case. A state bar court order of probable cause has been recommended.
Oh, wow.
Gingras has stated he intends to use this case to he intends to use this case to elicit testimony from Marracini that will aid in his defense in the investigation into his misconduct against Marracini. Why would you admit that to someone?
In the investigation into his
So
misconduct.
he's saying that he
Oh,
intends
yeah.
to use the case to benefit himself, is essentially what he's saying. Why would you say that to someone unless you were on crack?
I don't know. Are we speculating? This is wild.
No, he must have actually said that.
Yeah. This is wild. Because so we have the Judge Mata bar complaint, and we've seen snippets of that, right? And that clearly hits at some of the things that happened on June 10th at the paternity case, where Gingras was trying to get Mike Marracini disqualified as a witness. He called 911 to see if he could get him arrested for violating a protective order, even though he was under subpoena in Arizona. And so that would be interesting if Gingras was trying to use this renewal to gather information about Mike in order to help him with his own.
But I thought that he was allowed
bar
to
complaint
be
defense.
the emperor king of all deposing people and all that stuff because of his, why do you need this for that?
Yeah, he's always threatening to depose Judge Mata's dad. He wants to depose.
Or Judge Mata's dad.
Before the paternity case, he wanted to depose everybody under the sun. He didn't want to go to the June 10th hearing.
Yeah.
Because he wanted to depose everybody. I mean, I don't know. I think it's part of his bullying style, in my opinion, is that when he can get people in that situation, he can maybe push them around a little bit or intimidate them.
Yeah. Okay, let's see. Mr. Gingras' personal interest in defending his own conduct and license creates a concurrent conflict of interest between his interests and those of his client in violation of Rule 1.7 of the California Rules of Professional Conduct. So again, why would you admit that then? Is the thing just like this stupid just like confuses me every time. I mean, like, surely there's a reason for this that I just don't understand, but no, it's actually just fucking stupid.
Yeah, pretty weird. Gingras has stated he intends to use this case to elicit testimony. Wow.
Yeah.
Yeah, we do need Omar because I want the citation for that. Like, when did he state that?
I refuse to ask him any questions until this is over.
I wonder if they just like had a phone call and he said that on the phone or something.
I have no idea.
You know what I mean?
Yeah. Expert says, "Hey, all, much love at rehab with my mom. Talk soon. Everyone, be sure and smash the like. Thank you, man.
Yeah.
I miss you too. But what's going on with your mom?
Shop smart, shop expert Mart. Oh,
I haven't talked to you in a while.
His mom's got some things going on, so
he's she's all right.
busy. He's busy helping with that.
I miss that guy. All right. Somebody says, "Be careful, Omar may copyright strike you for this." Well, if he does, I will ask David to help me with my rebuttal.
Oh no.
Oh God. Okay. I don't miss that at all. That was a whole mess.
Someone said maybe he said something in a tweet, but I think we were pretty quick to monitor his tweets.
No, I'm pretty sure that this must have been like a direct conversation.
Yeah.
Yeah.
I did a whole video about all his wacky tweets before he shut down his X account.
Oh, I know. I got around to listening to it. I was like, oh, this is awesome.
If you want to see all his final tweets, you can watch my video on that because they're all in there.
I think he'll be back. We'll see though. Yeah.
Yeah, he would cancel and uncancel.
Yeah. Yeah.
That's his style.
Mr. Gingras is a necessary witness on pivotal contested factual issues in the DVRO renewal hearing, specifically his alleged misuse of law enforcement to have respondent arrested on a baseless charge of violating the DVRO, which is also the subject of the bar complaint involving Marracini, for which the Arizona State Bar has recommended an order of probable cause. Mr. Gingras' dual role as advocate and witness contravenes Rule 3.7, the advocate-witness rule, which generally prohibits an attorney from acting as trial counsel in a matter where he is likely to testify on a material matter. None of the narrow exceptions to this rule apply here, as Mr. Gingras' testimony relates to a hotly contested incident central to the case, not to an uncontested issue or mere formalities.
That's true.
Petitioner's consent, if any, to Mr. Gingras' dual role does not resolve the problem. I don't think that she had a problem with that. Yeah. Courts retain discretion to disqualify an attorney witness notwithstanding client consent to prevent prejudice to the opposing party or confusion of the fact finder.
With a legal citation. Very good.
Right.
Now, there are some adverbs here. There's some semicolons, so I'm going to give Omar a hard time for those. But
That's it. Back it
other
in.
than that, so
That's
far,
all
it's
we
pretty
needed.
good. Pretty good. It's kind of high and tight here. We're doing a good job.
Yeah. Somebody says the filing is on the Volo. Thanks, Winks.
Yeah, we probably need a link that we could pin or pin to the comments or something.
We got a couple different ways to look at it here. So like it's on the website, and then also this actually got sent to me by somebody who went to the courthouse and got it.
Yeah.
So I'm getting stuff from multiple avenues at this point. So just thank you to everybody who's doing it in whatever way you're doing it. We appreciate it. So.
Oh yeah.
My first time to be in your live stream, Lauren. So glad to be here. Oh, you're gonna regret that. But thank you.
Hey, TGIF. It's a good time.
Winks, let me pin this link real quick.
Oh,
that is the website where you can find pretty much everything. There we go.
Yeah, I think the bigger document is already up there, I think.
Yeah, it is. I haven't had a chance to look at it, but yeah. And the person who sent me this, I don't think they want to be identified. That's the only reason I'm not.
No, that's fine.
Yeah,
it doesn't. Yeah.
Well, I'm going to tell you right now, and then they're going to go to jail. So. All right.
I mean, obviously, if somebody, we thank everybody who's doing hard work here for their work, for sure.
Anyone who's working harder than me gets a pat on the back because I'm not doing anything.
Just because they're anonymous doesn't mean we don't appreciate them. So.
No, for sure, because I couldn't do this by myself.
Yeah.
Fuck that. Prejudice to respondent and threat to trial fairness. Allowing Mr. Gingras to continue as counsel under these circumstances will prejudice respondents' rights and undermine the integrity of the proceedings. Mr. Gingras' personal stake in the outcome, avoiding self-incrimination or further discipline. Well, I mean, he's doing a good job of that outside of this. Just making that happen. Creates a risk that his advocacy is driven by self-interest rather than his client's best interest.
Shocking.
His presence as trial counsel will also force respondent to confront and possibly cross-examine Mr. Gingras as a witness, an inherently prejudicial scenario that blurs the line between argument and evidence. This dual role could mislead or confuse the court and impugn the integrity of the judicial process, which the court has a duty to safeguard. So I was telling Omar last night, this is the first time I'm seeing this, but I was telling him last night, we were talking about the Justin case. And I said at one point, I was like, I just want there to be an amateur league where you have to fight each other on legal grounds, but you're nobody's a lawyer, you know what I mean? But I want there to be low stakes. I don't know. I feel like I would watch.
What? You want tilted court? Is that what you want?
So I'm thinking of Mike trying to do his own cross exam or something. I would watch the shit out of that. Where people just come in and they're.
That's hot bench, isn't it? I don't know.
Nah, I don't know because they have the 3 judges there. I don't want any judges. I just want
Well, who's in charge? Me?
American Idol style. Maybe ask the audience. You know what I mean?
Text.
Right, text your vote to whatever number.
Text star 69 Moose to cast your vote.
People who are arguing with each other, but I don't want there to be any order. I want it just to be a total mess.
A mess. Well, that's just the internet in general, Lauren. That's just people arguing with each other.
But I can't keep up with everyone on the internet, Bruce. I want people to spotlight the mess for me.
I mean, that's fair.
Yeah.
You want curated chaos.
Yeah, I don't want to have to go through all the comments from people who went to school and stuff. You know what I mean?
Curated chaos. That would be a good name for a TV show or vlog channel or YouTube channel. Curated chaos.
Oh, you're so smart.
Somebody should snatch that up.
Yeah. 1 second. Hold on. I was just making sure my messages were not from my boss. Okay. This motion is and would be based upon this notice of motion, blah, 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 blah. Stuff that doesn't matter. Okay.
What? There could have been something good in there. No,
there's nothing good in there, but you're welcome to skim it for yourself. I'm just saying basically that there's going to be an attached memorandum.
Look at Omar's signature for a minute. This thing is, look at this. This is real. It's got long lines.
Would anyone read this and think it said Omar Serrato? I just want to know.
No, it doesn't need to. Here's the thing. When I was an intern for the state of Wisconsin Bureau of Healthcare Financing, my boss, he was a real bureaucrat, he was a good guy, but he was a real bureaucrat. Anyway, I was an intern, so I had to learn all these things. And one week, his job was teaching me how to perfect my signature because you had to write a lot of memos back then and sign them and get copies made and put them in the mailboxes of everyone and stuff, or scan them and send them out in email because email was very new back then. And And I was just like, this guy just spent several days teaching me about the importance of a signature. Like you want to use, thick lines, and you want to always look the same, and you want to have smooth lines. And Omar's got the smooth lines, high quality stuff here. But, that was the moment I realized that bureaucracy was not for me and I should just go into a regular tech job. Anyway, I digress.
Absolutely, man. I mean, one of my favorite things is when you tell me stories about your youth in 1840.
Yeah.
So,
they were inventing the printing press and email. I mean, it was a wild time. It was a wild time in life.
The best I can do is I was growing up when we still had cord phones and stuff. So,
ooh, yeah.
I know, crazy times. Fake Laura Owens, thank you for the $10. Hi, real Laura. We know you're watching. That is absolutely true. You deserve everything coming your way. I think it's probably a Domino's pizza. P.S. Eat a sandwich. Oh, well, I mean, I think, like I said, I think it's probably a pizza because she orders it every day, like she said in her blog. So I don't know if she needs a sandwich. She has a pizza.
What is was that whole wheat? What was that? No.
A whole sandwich.
It said WH.
Oh, no.
I don't know.
WH. I don't know. Actually, I don't know what she's trying to say there. But
with ham?
I mean, I was assuming that was the real Laura, so now I'm confused.
With ham?
Yeah. Yeah. All right, so now we can move into this memorandum. Let's see.
I love a good memorandum.
I'm going to try to... We don't need to look at this part here. Petitioner filed a request to renew, because this is just like the history of this whole thing. The hearing was held August 15th. We know what happened there, but David Gingras has since indicated to counsel Omar Serrato, both verbally, wow, and in writing, that he does not intend to represent Laura Owens in these proceedings. Okay, so they did obviously have private conversations.
So we had to add this addendum.
Yeah. This motion is to ensure that he is in fact disqualified from representation due to major conflicts of interest. This motion is expected to be unopposed by petitioner.
Yeah, like you still want to file it because the guy could have been BSing, or he could change his mind, or he could leave and come back. So you gotta get this on the record.
Yeah,
it's very important. So Omar's dotting the I's, crossing the T's.
All right. Well, here's my kind of thoughts on this mess. She is the person who tried to file a motion to force Clayton to communicate with her. So I would not be surprised if she objected to this in some way and filed a motion to disqualify his attorney. You know what I mean? I don't know. On what grounds? I don't know. She's pregnant with twins again? Who cares? She's probably going to be crazy in some way about this. If she's on her own. That's what I'm saying. If she's on her own. If she has an actual attorney, maybe not. You know what I mean? But
she'll try to disqualify him. I mean,
she won't be successful. She's an idiot.
No.
But
I mean, but file a motion.
Yeah. Sure. No, she would try. I mean, she would try everything under the sun.
Yeah.
Because she's unchained now. She doesn't have a coked up lawyer to help her. So.
Oh dear. Well, if you go back to the Lori Vallow-Daybell case, she filed 3 or 4 motions to disqualify her judge over the course of 2 different trials, because it was the same judge for both trials, right? And in Arizona,
I didn't actually watch all that.
Yeah, she tried to disqualify him many times because she just said, well, you're just biased.
Yeah.
And it's like, well, what is this bias? And she just didn't like the fact that he was ruling in accordance with law and fact, The judge was actually very amenable.
She will try to disqualify Omar because he's Greg. That's probably true.
I mean, yeah. I mean, it's tough out here being Greg. I mean, we are all Greg. So
I feel like Greg. Yeah.
Yeah.
Absolutely.
Tough times.
All right. Forget that. Gingras attempted to illegally engineer respondents' wrongful arrest during the DVRO period by misusing the restraining order in this case, involving law enforcement under false pretenses. Marracini was lawfully subpoenaed, Exhibit A, there's a subpoena to appear, to testify at trial in Maricopa County, Arizona, scheduled for June 10th. As admitted by David Gingras in his declaration to this court regarding the instant renewal, he was aware there would be legal consequences for his failure to obey the subpoena. And I guess Mike would be aware of that, right? Is that what we're saying?
Yeah.
So if Mike did not, obey the subpoena, he could possibly be, facing consequences for not doing that.
Yeah, I believe that was part of the original.
Okay, so here's part of the declaration
for the renewal.
Finally,
this.
please note that it is a felony under Arizona law for any person to unlawfully withhold testimony, to evade legal process to appear, and or to fail to appear when legally summoned. For avoidance of any doubt, nothing in this, and then it cuts off because he was just putting this in there to show that he understood that failing to appear when summoned is an issue. It's doubtful that David Gingras, who's been in practice for roughly 25 years,
Oh dear.
has as profound a misunderstanding of the law that he reasonably believes Marracini violated the DVRO by complying with a validly issued subpoena, yet he cites in his declaration Arizona's Rule 49 regarding discovery disclosures as a valid basis to threaten Marracini with arrest in an email to David Woodnick? I think he means Greg, right? Greg. Woodnick.
Oh, we got a typo, guys. Yeah, Greg Woodnick.
David Woodnick. Do they get married finally? He is in love with Greg Woodnick, so I mean, maybe they joined in matrimony. I don't know, man.
That seems unlikely. That seems low probability.
Yeah, I don't think Greg would say yes to that.
We're more likely to find Bigfoot.
Well, never mind. P.S. This goes without, and he's quoting him again. P.S. This goes without saying, but to the extent I suggested Mike would be arrested if he comes to court in Arizona, that suggestion is completely and totally withdrawn. But yet he called the fucking... Okay. I only said that because I didn't want Mike to show up without giving me the chance to at least interview him as I would with any normal witness. As long as Mike agrees to have a reasonable call to answer some questions, I'll stipulate and agree his appearance in Arizona is not a violation of anything, and we will not expose him to arrest or any other legal consequences. Damn. Okay.
Yeah, so it's all just intimidation and,
yeah.
You know, what is it when you're trying to get something from someone?
I don't know where you're going. I don't know where you're going for. So,
in any case,
I haven't had enough caffeine today. Let's see. The issue regarding Marracini's testimony was addressed in a motion in limine. Is that how you say it? Limine?
Yeah, some sort of coercion.
I used to say lemonade, so I don't know if it's saying it right or not. Filed by Greg Woodnick and addressed by Judge Mata prior to the trial of Owens versus Eckerd. David Gingras argued.
That's what I'm looking for.
Okay.
This all reads like extortion when it's all laid out like this.
Well, remember when she tried to sue Clayton for $1.4 million, like before the trial? It's like, drop this or else.
They're too fishing upon them.
Yeah. David Gingras argues in his declaration a violation of Arizona Rule 49 regarding disclosures as the reason law enforcement was called, which Woodnick refutes and offers the basis behind Marracini's expected testimony, namely that Mr. Marracini's testimony is important to show her motive, intent, plan, preparation, knowledge, and absence of mistake. There was extensive litigation in San Francisco regarding these parties. Owens claimed to Marracini that she was pregnant with his twins, that she miscarried, that she needed to take abortion pills / have a DNC because she had a severe allergic reaction to the abortion drug, and that only one of the fetuses was terminated. And that was bizarre, by the way. I remember those text messages. Laura also allegedly told him she had ovarian cancer and that she had to have an ovary removed, fabricated medical records to support this, claimed that she might have cervical cancer and that she might have Sherman syndrome and Crohn's disease.
Asherman syndrome. This lady has more stuff wrong with her than...
what is Asherman syndrome?
Well, it's like...
I don't remember.
I don't know. You got to go watch House or something to see. I think it's pretty rare. But this lady's had so much stuff wrong with her. They need to do a medical textbook just devoted to all this stuff.
No, everything that's wrong with this lady's in her head. So
I think the Instagram account has done like a list, right, of all the different things she's claimed.
Yeah, probably.
Sounds about right. Gosh. Wild.
Laura, after seemingly realizing that Marracini provided relevant information in the instant litigation, has since claimed that the medical records Marracini provided, disclosed to Laura, were fabricated. Ostensibly, Marracini was distressed by Laura via counsel, posting the 2018 deposition and blogging about him being a liar and 100% false, which led him to surrender his laptop to a San Francisco-based computer forensic expert, John Berryhill. Mr. Berryhill analyzed thousands of pages of text messages and medical records communicating between Laura and Mr. Marracini and determined all text messages / medical records from Laura's phone number came from Laura. meaning Laura appears to be continuing to commit perjury by filing affidavits that disclaim texts and medical records that she sent. It is no
Right.
wonder she does not want Marracini addressing her intent, motive, knowledge, absence of mistake, and preparation, despite his testimony being admissible under the rules. God. All right. Gingras attempted to harass Mike Marracini through social media, through his former attorney Randy Supalik, and ultimately with the Phoenix Police Department in an effort to intimidate a witness into not testifying at trial. And then they have exhibits F through R. Okay. Where he's like taunting him or whatever. And I remember when David posted that like picture of David, or not David, Mike and Laura together.
Oh
And
yeah.
like talking about their relationship, and I was like, what fucking lawyer does this?
Mm-hmm. I mean, I think Mike was going to actually get on a phone call with this guy.
No, yeah, and
before
then he
did all that, but I don't know. Gingras continues to throw himself under the bus.
Yeah, absolutely. All right. When Marracini arrived as directed in the subpoena, David contacted the Maricopa County Superior Court's security department to advise them of the situation. He then contacted court security to explain the situation and to ask them to enforce this court's order. The Phoenix Police Department arrived shortly thereafter, whereby David provided them with a copy of this court's order and asked them to enforce the order as required by federal law. A huge scene was made shortly before trial began because of the large presence of law enforcement. Gingras' transparent attempt at witness intimidation became moot as Marracini, although a named witness, was not called to testify. And I remember Laura made like a big deal about him saying he knew he wasn't going to testify or whatever, in the case in one of her recent filings. But like he got there and they had 2 hours, and he was like, you can say like I'm pretty sure, or I know I'm not going to testify because you only have 2 hours, so it's reasonable for him to conclude that. But you still have to show up in response to the subpoena.
Yeah, I mean,
that.
You have to be ready to go because
Right.
you never know. I mean, even with 2 hours. Yeah. There's a chance you could get called in a different order or something like that. So there's a chance. I think there are even cases where judges will go a little bit over time depending on their calendar.
Yeah.
I think I've heard that. I don't think that happens too often, but that's theoretically possible. So, and really it's, if you're confident, it's a matter of confidence, right? Like, it's not like the court emailed Mike and said, we're definitely never going to get around to calling you, or some lawyers told him that. That's not what happened, right? That's how you would know something, as opposed to having confidence in an opinion. Okay. Mm-hmm. So when Mike says to Megan Fox and Dave, I kind of knew that I wouldn't be able to make it up on the stand. Okay. Right. That's just a confidence level. He's just speaking casually. Mm-hmm. He's not speaking sort of scientifically in a precise way, because why should he have to? He shouldn't have to.
Right. Yeah. Let's see. That incident, which respondent contends was a bad faith abusive process by Mr. Gingras, is a central disputed issue in petitioner's request to renew the DVRO. Mr. Gingras is a percipient witness to the event, and his credibility and conduct are directly in question. Compounding this, Mr. Gingras now has a personal stake in the case beyond his role as advocate. Respondent filed a state bar complaint regarding Mr. Gingras' conduct in this matter. The Arizona State Bar's independent review has resulted in a recommended order of probable cause, meaning the bar is proceeding in its investigation under the belief it has sufficient evidence of ethical violations by Mr. Gingras towards Marracini to initiate formal disciplinary proceedings. All right, and I guess they have the exhibit there as well. He enters the DVRO renewal hearing with a serious conflict of interest. His own professional fate is at risk based on the facts of this case, creating strong incentives to vindicate himself or minimize his wrongdoing. Much of the basis for Owens' renewal request is focused on Gingras' personal grievances against Marracini and has little, if anything, to do with Owens' reasonable fear required to move forward with her request.
Accurate.
California law holds paramount the duty of attorneys to avoid conflicts and to maintain the integrity of the judicial process, whereas here, an attorney's personal interests materially limit his representation, and where the attorney is likely to be a necessary witness on contested issues, a court has both the authority and the obligation to disqualify counsel in order to preserve public trust and the fairness of the proceedings. All right.
Very good.
Respondent does not bring this motion lightly, recognizing that parties are generally entitled to counsel of their choice. However, the California Supreme Court has emphasized that the important right to counsel of one's choice must yield to ethical considerations that affect the fundamental principles of our judicial process. In short, the paramount concern must be ensure a just proceeding untainted by conflict or attorney self-interest. Accordingly, respondent moves to disqualify Mr. Gingras on 2 primary legal grounds: 1, conflict of interest, and 2, advocate witness. In combination, these factors demonstrate that allowing Mr. Gingras to continue as counsel would prejudice respondent's rights and the integrity of the court. Yep. All right. Let's see. Legal
Good
standard
arguments.
for disqualification of counsel. What do we got here? California courts have inherent authority to disqualify an attorney when necessary to protect the integrity of the judicial process and the rights of litigants. A motion to disqualify involves a conflict between the affected party's rights to chosen counsel and the duty to uphold ethical standards in litigation. So here's where we get into like a lot of these citations and stuff. Not gonna lie to you, I'm probably gonna move past that. Disqualification is warranted for a variety of ethical violations, but 2 grounds are particularly relevant here. Concurrent client conflicts, okay, so personal interest conflicts. Under Rule 1.7, an attorney must not represent a client if there is a significant risk the representation will be materially limited, I cannot talk today, by the lawyer's own personal interests, absent informed written consent from the client. Even with client consent, some conflicts are so severe that they are not truly waivable if they threaten the fairness of the proceedings. The court may disqualify an attorney whose personal interest conflict poses a substantial risk to his ability to represent the client in order to protect the interests of justice. Will be materially limited by the lawyer's responsibilities to or relationships with another client, a former client, or a third person, or by the lawyer's own interests. We agree with the trial court's analysis. Simonian has failed to establish the court abused its discretion in denying his motion for reconsideration or in denying him to amend his complaint. Okay, so that's probably one of those things I skipped over. Give me 1 sec, I get some water. Can you read that one?
Yes.
Yeah.
Okay, this is the advocate witness conflicts. Rule 3.7, a lawyer may not serve as both an advocate and witness on a material issue at trial, absent narrow exceptions. This advocate witness rule exists to avoid prejudice and confusion, as California courts deem the dual roles irreconcilable, requiring partisanship as counsel and objectivity as a witness, thereby undermining fairness. Okay, and then there's a citation for a case. Even if a client were to consent to such a dual role, the court retains discretion to refuse to allow it to protect the trier of fact from being misled or the opposing party from being prejudiced. Okay. And that would be, yeah, that I mean, even for a judge, that would be confusing if you had a lawyer who was the lawyer and a witness giving testimony. I imagine it could be very confusing for a jury in a jury trial. In deciding a disqualification motion, the court must examine the totality of the circumstances and determine whether the attorney's involvement would have a continuing effect on the proceedings such that the fairness or appearance of fairness is jeopardized. Another case citation there. What does that say? When an attorney's continued representation threatens to undermine the integrity of the judicial process or impacts the moving party's interest in a just determination of the case, the court must exercise its discretion to disqualify that attorney. Ultimately, the trial court has an independent interest in ensuring trials are conducted within ethical standards and that legal proceedings appear fair to all who observe them. Yeah, and it's really that appearance of fairness, regardless of whether or not it's like literally fair or unfair. You want to avoid any appearance of impropriety or ethical issues or anything like that, both in the legal space and in the corporate space. Okay, where was I? I don't know. And there's a case citation. This independent interest exists regardless of whether the attorney's own client objects to the conflict. Even a non-client litigant, like the respondent here, has standing to seek disqualification when the attorney's conduct infects the litigation. Oh no, guys, we got to get some what are those called? Antibiotics. We're getting infected by Gingras. Ooh, and threatens a cognizable interest in the moving party in a fair proceeding. Against this legal backdrop, both prongs of Mr. Gingras's conflict. Oh, he has 2 antlers. Only 2?
Oh my God.
He's a 2-point buck, guys. That's kindergarten. Okay, anyway. Both prongs of Mr. Gingras's conflict are squarely presented in this case. We can address each in turn. Didn't they just do that? I don't. Anyway, argument. Oh, man, this is comprehensive. This is comprehensive.
Yeah. So I got just now got express permission from my friend that I was allowed to tell you that my friend Steve went to the courthouse to get this for me. So thank you, Steve.
Yeah.
Yeah, I just wanted to make sure. I don't want to say his name or anything, but he texted me because I guess he saw that. So
nice.
Yeah,
Steve is out there doing
solid. Yeah,
doing quality work.
Okay, where are we at here? Arguments. David Gingras's personal interest in avoiding discipline conflicts with his client's interests. Gingras's ability to represent petitioner with undivided loyalty and independent judgment is materially compromised by his own personal interest in this matter. Right, we already know Rule 1.7. That is precisely the situation here. Gingras's personal conduct regarding respondent is under official scrutiny, and he has a powerful incentive to protect himself, to defend his reputation, and avoid professional discipline arising from this case. This creates a significant risk that his representation of Miss Owens will be skewed or impaired by considerations of self-preservation. The Arizona State Bar's probable cause finding is an objective indicator. Gingras's conduct in this matter is in serious question. When an attorney's own actions are at issue in the case, ethical authorities warn that it may be difficult or impossible for the lawyer to give a client detached advice. An attorney cannot be neutral or wholly loyal when his personal wrongdoing is intertwined with the client's case. And we've seen that rule already. Here, Gingras's alleged misconduct towards respondent, misuse of the DVRO and law enforcement, is a central issue. He has personal stake in denying or minimizing that misconduct. This personal stake directly conflicts with his client's interest in a full and truthful adjudication of the DVRO issues. If certain evidence in the renewal hearing might vindicate respondent's claim of attorney abuse and thereby bolster the state bar charges against Gingras, Gingras has a temptation to downplay or suppress that evidence, even if it might be relevant to Miss Owens' case. Conversely, Gingras might be tempted to overemphasize, he would never do he never does that, or even fabricate justifications for his prior conduct to protect himself, evidenced by his major emphasis on the incident related to the Arizona bar investigation highlighted in his declaration, thereby diverting the hearing's focus away from Miss Owens' actual interests. In either scenario, his personal interest in avoiding discipline pulls against his client's best interest in an objectively fair presentation of facts. All right. California courts have recognized that an attorney who is simultaneously defending his own conduct while representing a client in the same matter operates under a disqualifying conflict. And I guess he's citing a specific case here. For instance, an attorney was disqualified in a family law case due in part to his emotional involvement and personal entanglements that compromise his objectivity and loyalty in representing his client, who was his son. The court noted that such multiple roles and personal stakes undermine the integrity of the judicial system and create at least an appearance of impropriety that cannot be ignored. So here for footnote 3, it says Laura Owens' petition for renewal was undoubtedly authored by David Gingras. As his declaration virtually mirrors the facts set forth in Laura Owens' petition. The overwhelming basis of Owens' petition is centered around Marracini complying with a lawful subpoena, where Gingras is alleged to have abused the DVRO process and law enforcement to intimidate a witness. Yikes.
Exactly.
Yeah. A client's consent to a conflicted representation does not bind the court when conflict threatens the fairness of the proceeding. Courts reserve the power to disqualify an attorney if the conflict poses a substantial risk to the attorney's ability to competently and loyally represent the client, or if it undermines the adversarial process, notwithstanding the client's willingness to proceed. As the California Supreme Court has observed, some conflicts are so severe that even informed consent may not suffice to avoid prejudice, especially where an attorney's judgment may be impaired by personal considerations. Right. In this case, disqualification on conflict of interest grounds is warranted because Gingras's personal interest in his own disciplinary outcome is paramount and irrevocably at odds with his client's interests. The situation creates, at the very least, an appearance of impropriety and a genuine risk that Miss Owens will not receive unbiased, conflict-free representation. The integrity of the court's process is likewise at stake. The fact finder should not have to wonder whether the petitioner's counsel is shading his advocacy to save himself. In short, Rule 1.7 prohibits Gingras' continued representation, and the court should exercise its discretion to disqualify him on this basis alone. All right. You want to take this one?
Gingras must be disqualified under the advocate witness rule, Rule 3.7. Gingras' role as a key percipient witness independently mandates his disqualification. Yeah, I mean, if he's the lawyer and the witness, how's he going to give himself hand signals when he's questioning himself? Anyway, Rule 3.7 bars an attorney from serving as both advocate and witness on a contested issue, absent narrow exceptions that do not apply here. The June 2024 incident, where Gingras reported responded to police, is a misleading attempt to have him arrested with knowledge Marracini was complying with a lawfully ordered subpoena in an effort to intimidate a witness on the day of trial, is central to petitioner's request for renewal. Only Gingras can testify about his own statements and motives during this episode, making his testimony necessary and material. Courts have long held that dual roles of advocate and witnesses are irreconcilable, as one requires persuasion and the other objectivity. Okay. Allowing Gingras to continue would create multiple prejudicial effects. One, misleading the fact finder by blurring advocacy with testimony. Two, prejudicing the respondent, who would be forced to cross-examine opposing counsel. And three, improperly bolstering Gingras' credibility through his dual role, as warned in Comden versus Superior Court. Okay, even with client consent. Comment 3 to Rule 3.7 confirms the court retains discretion to disqualify counsel to protect fairness. Very good. Petitioner can readily secure substitute counsel, but respondent's right to a fair trial would be greatly compromised if Gingras remains. The equities thus decisively support disqualification.
Yeah, and her securing substitute counsel at this point is going to be a little more difficult since the family's in bankruptcy proceedings, obviously, and she can't pay for shit by herself, really, unless they, gave her money before they did all that, but somehow without declaring
unless
it.
she finds that $450,000 bank account she claims she had.
What the hell happened to that, right? That's crazy.
Back when she was looking at houses with Clayton.
Yeah, their financial situation is very odd to me, but, me and Tiff and the rest of us are going to talk about that more on Sunday, I think. So obviously there's that, and then of course she could try to go back to that like advocacy group or whatever, but at this point it's like there's so much evidence that she's not told the truth about stuff, and there's a judgment against her in Clayton's case, so it's like, would they take her case the way they did before? I don't know.
That's a good question. I think it would be fine for an organization like that to look into this case, because they can look at all the evidence and all the background and all the outside context. And, it's just more, I always like more eyes on a case, more eyes on a problem, to get a different point of view or to help more people get educated on what's going on.
Yeah.
So if there's an advocacy group that wants to take a look at this, please do. We've tried to get the TEDx people to take a look at all the activity that's gone on in the court system with public documents, in the chance that they might reconsider the posting of the TEDx talk that she did. Right. And of course they're not looking at it. So I think it's always better for people to look at, I think transparency is always better.
Yeah.
In these things, in any case. And the thing is, so I saw a question in the chat. So the thing is, we know that Gingras is dipping out of this case on his own accord.
Right.
But the key here is that we want all of this material on the record, because this was being drafted before he dipped out of the case. And, maybe he was being a little disingenuous, or he might change his mind and try to come back or something like that. So we want these arguments in the court record, just to cover all the bases.
Yeah.
Yeah.
Well, he's going to come back like he comes back to Twitter. So
yeah.
you know.
Plus, reading through the document, we get to see all the good 1-2 punches that Omar is metaphorically applying here.
Exactly.
In the case, which is always good.
Somebody said, "What's the story with the court date for drunk driving?" It was postponed a month.
Right.
Till like end of September or something.
Yeah.
So yeah.
I mean, that'll give him time because he sold his boat, right, and bought a plane ticket to the East Coast. So, now Gingras can like take his money and like buy one of those Miami Vice boats and like drive to Cuba or something, and like where they don't have extradition, and he can just. That'd be my advice.
Yep.
Anyway,
KW says Omar is scary smart. So I just want to tell this story.
Yeah.
Okay, because like I said, I'd never seen this guy's legal writing before. So if I were reading this legal writing, I might just think he's really smart too. But I was in his office a couple months ago, and he couldn't remember the Wi-Fi password, so I could get on the Wi-Fi. And so his solution to that was to disconnect himself from the Wi-Fi that he doesn't know the password to. And so then we were both sitting there without Wi-Fi, and he couldn't do anything. So I don't know. When somebody says he's scary smart, I'm just that's all I can think of. It's like, this is the guy who disconnected himself from the Wi-Fi because he didn't know the password.
Oh no. Well, I mean,
we figured it out. It's all good.
I mean, there's different domains, right? Like nobody's 100%. Nobody's like smart or not smart, right? It's not like a binary thing. It's like
my guy thought if I disconnect myself from the Wi-Fi, I don't know the password to. When I come back onto the Wi-Fi, it'll show me the password.
I mean,
yeah,
that's an idea.
Yeah, it was an idea, man. It was an idea.
I don't think Brad would have advised that, but
I don't think Brad would have advised that either. I mean, there's a way you can go and like view your password in your computer's like safe for free, but he just didn't know that, I guess.
I mean, there's different domains. Like I knew a literal brain surgeon, like somebody who did brain surgery on people.
Yeah.
But when it came to like home repair and home maintenance, they just didn't know anything. And it's like, people can have different talents.
I'm just saying I'm not scared by his intellect.
Oh boy.
He's very smart.
In a legal document I would be. Oh my gosh. Maybe not in an IT shop.
No, he's like 40 worse stories about me, I promise. So.
Oh boy. Okay. Where are we here? What's happening?
Where did we get to here? Are we on C yet?
Yes.
Yeah, okay, cool. The combined effect of Gingras's conflict and dual role threatens the fairness and integrity of these proceedings. Even if either of the above grounds alone might suffice, together they present a compelling case for disqualification. This is a situation where an attorney's personal interest conflict and advocate-witness conflict intersect, compounding the potential for injustice. Because Gingras's personal interest gives him motive to color the evidence and arguments in this case to suit his own ends. This undermines the court's confidence that petitioner's case is being presented ethically and objectively. Simultaneously, Gingras's status as a key witness means he is effectively an unsworn participant in the event being litigated. The fact finder must evaluate Gingras's actions and credibility, yet Gingras, as petitioner's lawyer, would also be packaging those facts for the court. From respondent's perspective, these conflicts materially prejudice his rights. He faces an opposing counsel who might distort the truth. He totally would. To protect himself, and whose factual claims cannot be tested by normal means, since that counsel also controls what evidence is presented. This is antithetical to a fair adversarial process. From the court's perspective, the proceedings risk devolving into a trial about Gingras's conduct. Well, he probably should be on trial for his conduct, but not in this one. Rather than the parties' issues, creating a sideshow that detracts from adjudicating the DVRO renewal on the merits. Additionally, the court must worry that any decision granting or denying the DVRO renewal could be tainted by the perception that one side's attorney had a personal axe to grind, or that his dual role influenced the outcome. This threatens the integrity and public trust in the judicial outcome. In sum, allowing Gingras to serve as petitioner's advocate would materially compromise the fairness of the DVR renewal hearing. It would place respondent at an unfair disadvantage and interject Gingras's personal issues into a proceeding that should be about the parties, not the lawyers. The prudent and just remedy is to disqualify Gingras now, before the trial, to ensure that upcoming hearing can focus on the merits, with both parties represented by conflict-free counsel and all witnesses, including Gingras, testifying without also acting as advocates. So we're basically at the end here. For these reasons, respondent Mike Marracini respectfully asked the court to disqualify David Gingras from representing petitioner Laura Owens in this DVRO renewal. All right. Let's see. By removing Mr. Gingras, the court affirms that justice must not be clouded by attorney conflicts or dual roles, thereby safeguarding both parties' rights and the integrity of the tribunal. Okay. And then there's someone's signature again. I'm not sure whose it is. I can kind of make out an O. I can kind of make out an O there.
You can see the O and the S. It's good. That's what you want.
You guys just see my people say like doctors and lawyers and stuff have like the worst signatures. My dad's signature, he's a psychologist, is it's just like chicken scrawl. It's like, what even is this? No one could ever.
Smooth?
It's not. Yeah, it's not just his signature though. It's his entire handwriting.
Oh,
I'm like,
handwriting.
Oh my god, who could fucking read this?
Yeah, I mean, signatures are different than handwriting. Handwriting, you want to be legible. Signatures, you just want it to be iconic.
Yeah.
I think the interesting thing in that last section was really the important part is whether or not there's a conscious or unconscious opportunity for bias, right? Like that's the key, because anybody can say like, oh, I'm going to be fair. I'm not going to be prejudiced against anything, or I'm not going to do anything incorrect. But subconsciously, you can't control these biases, right? When you're doing things, and over a long period of time, these biases can crop up, even with the best of intentions, right? And of course, none of us probably would consider Gingras to have the best of intentions. Just my opinion.
Yeah. Okay, so this is his declaration, I guess, in support of this.
Yeah.
Let's see.
Consistent and distinguishable. So you want to know it's the person's. You want to know it's the person's signature. Like that's why it's a signature. It's Omar's signature. It's his.
Yeah. Right.
Signature look, and you want to do it consistently. That's the key. Because if you have 5 documents and all the signatures are different, people are like, "What's going on? Is there fraud happening here? What's going on?"
Yeah. All right. Let's hang on. Let me move this real quick. I'm informed and believe, and thereon declare, that Mr. Gingras is a recipient witness to significant disputed events underlying the DVRO matter. In particular, on about June 10th, during the period that the current DVRO has been in effect, Mr. Gingras contacted law enforcement and reported an alleged violation of the restraining order by respondent Mike Marracini. Mr. Gingras' report led to law enforcement officers confronting Michael Marracini. No charges were ultimately filed, nor was he arrested for any violation against respondent as a result of that incident. Respondent's position is that the above incident was a false or exaggerated claim orchestrated by Mr. Gingras to harass or intimidate respondent. Respondent disputes that he violated the DVRO at all and contends that Mr. Gingras misused his role as petitioner's attorney by involving the police without a valid basis. This incident and the parties' conflicting accounts of it is expected to be a key issue at the DVRO renewal. Petitioner, through Mr. Gingras, has cited respondent's violation of the DVRO as a reason the restraining order should be extended, while respondent will argue that the incident shows an abusive process by petitioner's side.
And the interesting thing there is there really aren't any other reasons to renew this DVRO. I mean, they don't live anywhere near each other.
Yeah.
Mike hasn't communicated with her directly or tried to, be in physical proximity of her outside of this subpoena. So this is really the only, other than just like, well, if I think about him, I might feel scared. I don't think that's good enough, right? There's no, at least with all the evidence we have from this case, it's not good enough.
No.
For a lifetime DVRO renewal.
No, it shouldn't be.
Right? I mean, maybe I feel scared is good for temporary, so you can figure things out. But this is the time to figure things out. And it's really not a good argument. It's like their only argument.
Let's see. I am informed and believe that Mr. Gingras has personal knowledge of and involvement in the aforementioned incident. Mr. Gingras is the person who spoke to the police. Thus, he is a necessary witness to explain that what he reported and why. To my knowledge, no one else can provide the same testimony regarding Mr. Gingras' communications and intentions in calling law enforcement. The accuracy and account of Mr. Gingras' actions during that incident are directly at issue in determining whether respondent violated the DVRO or whether the incident was a misuse of the DVRO mechanism. Respondent Mike Marracini filed a complaint with the Arizona State Bar concerning Mr. Gingras' conduct in relation to the DVR case. The State Bar complaint focuses on his role in the law enforcement incident described above, alleging that Gingras violated ethical duties. I am informed and believe that after an investigation, the State Bar of Arizona and are recommending a finding of probable cause to proceed with disciplinary charges against Gingras, finding that sufficient evidence exists that Mr. Gingras committed one or more violations of the rules of professional conduct in connection with his representation of petitioner Owens against respondent Marracini. As of the date of this declaration, Gingras' State Bar disciplinary proceeding remains pending. I am informed that no final discipline has been imposed and Gingras maintains an active law license. However, the State Bar proceeding is ongoing and could result in professional discipline, such as reproval or suspension, if the charges are proven. It is my duty to alert the California State Bar of the pending action pursuant to Rule of Professional Conduct 8.3, reporting professional misconduct. So I guess he did that. I think David had a duty to report that, yes? I don't know if he did or not. I think he was supposed to, but it looks like...
I'm not sure about that. I think if there are levied sanctions, then he's supposed to, if you practice in 2 states.
I'm a little, I'm not clear on that. So
I think a bar complaint on its own doesn't require reporting. As far as I could be wrong, I'm not a lawyer, I know.
Yeah.
But I'm not aware of any requirement. I think if there are sanctions, there may be requirements to report.
Gotcha.
The sanctions are actually enforced or levied.
Well, it looks like you got reported anyway, so I'm informed and believe that Mr. Gingras did not disclose. Oh, okay, here we go. Yeah, I'm informed and believe that Mr. Gingras did not disclose this to the court, the fact that he is facing a State Bar investigation / charges arising from this case. There has been no stipulation or waiver concerning this conflict filed in this action. I am uncertain whether or not Laura Owens has provided informed written consent waiving the conflict presented by Mr. Gingras' personal interest in the outcome. In any event, as outlined in the motion, I believe that this conflict is so severe that the fairness of the proceeding would be affected even if consent were given. I believe disqualifying Mr. Gingras will not prejudice petitioner Owens' case beyond the ordinary inconvenience of obtaining new counsel. We did not bring this motion for any improper purpose or tactical delay. Respondent's sole aim is to ensure that the upcoming DVRO renewal hearing is adjudicated on the merits without the process being skewed by counsel's conflicting interests or dual role. And then he declares under penalty of perjury, blah, blah, blah. Okay.
Ordinary inconvenience.
And this is just the proposed order that the judge would sign off on if they agreed to disqualify David. Yep. So that's that. God, and that was only the 27-page one. So the one tonight, I guess a lot of it's exhibits, the one we read tonight. So we'll actually go through the whole actual, thing. But then I don't know if we'll get through all the text and stuff like that that are attached to it because I haven't even gone over it yet. But yeah.
Yeah, it would be good if somebody could sort of scan through it quick and find the highlights.
Yeah, I'll see if we can do that. Because we're not gonna do that until 9:30 Eastern or something. So.
Otherwise, it'll just take way too long.
Yeah, so we got 5 hours. I'll work on that a little bit. I got an hour of work left before I can clock out, and then I can do that for a little bit. So, all right, thanks guys for hanging out with us and watching. Like I said, we'll be back later. I'll just go ahead and schedule it, and I'll post the link, and we'll see you guys soon. And thanks, Bruce, of course, for hanging out and doing this with me. So
yeah. So, Lauren, what's your grade here for Omar's first filing here?
I think he's great. Yeah, I think he's great. I don't have a letter grade for you because, I'm not a teacher. So, yeah, but I thought it was great. I liked it. I knew he would do a good job. I make fun of him a lot, but obviously he's a really smart guy. If he wasn't, I probably wouldn't, brag about him so much. If he was dumb, you know what I mean? So, no, I know he's going to do a good job, and I appreciate him. So, but yeah. Well, obviously,
I'll give him an A. I would give him an A+, but like Erica's saying, he did say David Woodnick in one spot, and then there were a few.
Whatever.
There were a few, adverbs, a few little adverbs here and whatnot. I don't know.
I've been to this guy's house. I've met his children and his wife, and he still calls me Laura sometimes.
Well, he gets me and Brad mixed up all the time with the BR names. God. So it's just good there's nobody that goes to Flat who's named Brian or something, because then it'd just be Bruce, Brad, and Brian. We would all just get completely mixed up.
Yeah, I get you.
Mm-hmm.
All right. Well, I gotta take off so I can get back to work and finish up, and then we'll be back to see you guys in like 5 hours or so.
Very cool.
All right.
Bye.
Bye, guys.